Statement.
Okay. So after reviewing the existing case law and legal commentary on petition rights, the law department's position is that the weight of the authorities on this issue supports the position that individual landowners do not have protest rights when a municipality seeks to enact a comprehensive revision of its zoning classifications and associated regulations. From yesterday, I understand Councilmember Poole to say that the answer to this issue may seem to fall within a gray area, and from a policy perspective, the council should consider the direction it wants to take. Of course, council has this prerogative, but there are a few things that I did want to address. First, one of the public memos that Councilmember Tovo was referencing that was released on May 14 states that, in part, authorities around the country, including Texas, have interpreted statutes authorizing zoning protests as limited to changes reclassing individual properties or distinct limited areas. Clearly, with the rezoning of individual property, the state law provides for very specific notice and protest rights. I have been asked, well, isn't that what we're doing here? Aren't properties being reclassified? Yes, properties will ultimately have different designations, but not because the individual property was considered for rezoning. Rather, the classification is the outgrowth of the council's holistic revision of the code. And herein lies the difference between a comprehensive revision of our zoning regulations and the rezoning of individual tracts. In individual tract rezoning cases, council is evaluating a very specific piece of property. Is the use compatible with neighboring existing uses? Will the height authorized by the requested zoning district hinder the air and light available to existing residents? On the other hand, with the comprehensive revision, council is looking at a bigger picture. What do we want our city to look like in 20 years? What overarching goals do we want the code to effectuate? Council stated those goals in its May direction to the manager. The staff created what it considered to be a code that responds to council direction. The changes on the map are an illustration and reflection of those goals and policies. The changes are not based on the specifics of any individual property, but rather on criteria based on broad policy goals. The revision is a policy decision affecting a large number of property owners and a vast area of land based on general criteria and not on the details of any particular property. Therefore, because the property owners would be affected equally by the legislative enactment of the comprehensive revision, the property owners don't need the same level of protection as when the city focuses on an individual property on small discrete areas. Second, protest rights do not exist in a vacuum. Protest rights are inextricably linked to state law notice requirements. If we were to consider the proposed comprehensive revision of our zoning regulations as individual zoning cases, as some in the public are requesting, then the city would also be required to send individualized notice to each property owner in the city, identifying the proposed change to the zoning on each individual property, and send notices to owners of property within 200 feet of each property within the city, or 500 feet if we follow the city's existing code regulations, to notify the neighboring property owners of the proposed change. One issue we have with the notice is that under state law, notice must identify the specific change proposed. At the point in the process when we would normally send notice of a proposed change, we had no certainty of what the new zoning district would be. Even at this late date, we are not 100% sure of what the zoning will be because council has not yet acted on final action. In addition, and of great importance, we will need to consult with the city's GIS team to determine the logistics associated with establishing the protest areas for each property in the city in terms of time and resources involved. Finally, I did want to point to a possible alternative method of establishing protest rights should the council decide that they wanted to do so. Here I reference to the method the city uses for neighborhood plan combining district zoning. The code provides that for NPCD zoning, the required percentage is the required percentage of land is based on the boundaries and area of the proposed of the entire proposed district. Since under this comprehensive revision, every piece of property in the city will have a new designation, the required percentage could be based on the entire area of the city. Under this method, a petition would be valid if the city received protests from the owners of 20% of the land in the city. Again, I don't know what the logistics are, but theoretically, this would be an alternative method that is in line with the process already established by the code.
Okay, thank you.